Welcome to Criminal Law Unfiltered.
Hello and welcome back to Criminal Law Unfiltered with Robert M. Helfend. Robert is the founder of Helfend Law Group and has spent more than 40 years defending clients in serious state and federal cases across California and nationwide. With thousands of cases behind him, he's known for strategic, aggressive defenses when the stakes are the highest. I'm Evan Mack, and today we're talking about mandatory minimum sentences. Robert will explain what they are, who sets them, and why they can make federal time so severe compared to state court. This is mandatory minimums, why federal sentences can be so harsh. Robert, sir, welcome back.
Nice to see you again, Evan.
What are mandatory minimum sentences and who is responsible for settling them?
Okay, you'll be surprised for this answer, but not to be political about it, but in the golden ages of federal law, there were no mandatory minimums, and there weren't what we call now the guidelines either. It was just like you see in state court. You have a judge, you have a prosecutor, and if you can't work out your case with the prosecutor, you can ask the judge, Your Honor, my client's willing to plead guilty. What would you do for him or her? And now what we have are mandatory minimums. And a lot of these mandatory minimums came into effect they were brought into this country by none other than Joe Biden, which is surprising because it's so harsh. And there's a lot of groups around this country trying to lobby Congress to get rid of mandatory minimums. And this country should get rid of mandatory minimums because what it does is takes out the discretion to give somebody a sentence that's appropriate. And so in federal court, you have what's called federal law, which is like in California, we have the penal code. So you can look up the elements of an offense. What is robbery? Robbery is, and how much time could I get for that? If you don't get probation, you could go to prison, and these are the sentencing ranges for that. And so it's the same thing federally. Federally, you could find out what is distribution of a controlled substance. Okay, well, here's what it is. And here's the sentence that's possible if you have this kind of a quantity. It's 10 years to life. Okay, so if you see something that there are different crimes that have mandatory minimums. Okay, so a lot of drug crimes have mandatory minimums based on the quantity. You can have a 5-year mandatory minimum, a 10-year mandatory minimum. There's aggravated identity theft, which is a 2-year mandatory minimum, which is consecutive to whatever else you're charged with. So if you have wire fraud in there, the judge has the power and to sentence you to 2 years on top of whatever you get for the wire fraud. And so there's child pornography, exploitation of minors, human trafficking, things like that have mandatory minimums in there. And the effect of a mandatory minimum means that a judge does not have the power to get under a mandatory minimum. And that's the problem. Okay, so whether or not you get that mandatory minimum is actually up to the U.S. Attorney's Office. And that's a problem because that is putting the cat in the hen house. Okay. And so it's just an issue. If the facts support, the charge of distribution of a controlled substance, hey, how are you going to talk a U.S. attorney out of giving you that sentence. I mean, maybe you can talk about, okay, how about if we talk about the quantity and lower the quantity? It's a problem. It's a problem because the factual basis of the plea has got to be true. So it's a difficult situation, and mandatory minimums are just putting people in prison, in federal custody for longer than they should be. So when you hear somebody say, don't make a federal case about it,
Right.
they mean that. It means that, yeah, it's a federal case, so it's going to be a problem. I mean, it's the potential to get sentenced to a lot of time in federal custody. And the only people that can get you out of that
Hmm.
is the U.S. attorney themselves.
Wow.
You can't ask the judge to rescue your client. They don't have the power.
So Robert, how do these mandatory minimums kind of interact with the federal sentencing guidelines, though?
Well, the federal sentencing guidelines they were created by Congress way back. I think it was the 80s. And the federal guideline is basically a score that is tabulated. And once you get a base offense level, and then you see if there are any additions to that, and then you get downward departures for acceptance of responsibility. If you have no record, now this was a new law that came in the last year or so. Now you have 0-point offenders. So if you have zero criminal history, you get another 2 points down, which is helpful. But in the guidelines, there is a provision which will get you under mandatory minimums. There are two different ways to get under a mandatory minimum. Now, in drug cases, there's a provision within mandatory minimums where it's called safety valve. If you qualify for safety valve, now safety valve can get you under the man-min and also get you roughly 2 points down in the guidelines. So to qualify for safety valve, you have to have like a minimal record, which for a few years, you could have a lot of criminal history and still qualify for safety valve. However, the U.S. Attorney's Office successfully appealed that, and now you have to have a minimal rule or minimal criminal history to qualify for safety valve. Now, that will get you under the man-min, and that means that you can then get judge's discretion. Once you get under that man-min, you can appeal to the judge's reasonableness to say, hey, my client is a mom. She needed the money. She was taken advantage of. She took these drugs over the border because she needed the money. She didn't know how much was in there. And the judge could actually then do what he or she wants and not give you that man-min because you got under it with safety valve. The sticking point with safety valve with a lot of people, and this will tie into what I'm going to talk about next, the issue with safety valve is you need to go in and speak with the prosecutor about your crime. And so if you're going to still get time, people in prison will know that you got safety valve, and that means you went and you spoke about your crime. Now, it's not quite cooperating with them and naming names. So when I do a safety valve, I try not to name names so that, they're not labeled the rat, so to speak. You're not labeled as somebody that told on the people they did this crime with, because you don't want to go to prison and then, people in prison know you did that. So it's a problem. And sometimes people don't even want to do safety valve, which brings me to the next topic, which is there's another provision within the guidelines where you can cooperate with the government and tell them all about your crime and who did it and where they got it and their supplier, and you're naming names. And cooperating with the government can get you, 5, 6 levels down in the guidelines. And so it can substantially reduce your sentence. Of course, people that are in prison, they want your paperwork when you get there. And meaning they want to see your probation report. They may want to, or they might be able to look up your docket, and they'll see all of these filings under seal. And so they're going to know, oh, you cooperated, didn't you? So, it's a sticky situation for people, whether or not to cooperate with the government in their case. They have to consider now the safety considerations, not only for them,
right,
but for their families. And it's a real thing. And it seems to me that the federal government, yes, they want your information. They love information. The federal government, oh my God, it's like oh my God, they trade in that commodity. They love information on their citizens, especially.
Sure.
But once they get that from you and they give you the benefit of the bargain, which is a lower sentence, they're recommending a lower sentence to the judge. Your Honor, Mr. or Mrs. Smith did substantially assist the government, and we're recommending, a 6-level downward departure. At sentencing, and I've had this happen before, we can always bring up to the judge, that's not enough. That's not enough. They gave him 5 or 6 points down. Your Honor, this guy or this gal gave them the head of this cartel, and they were able to arrest this person, and or they told them where the body was. Your Honor, so 5 or 6 points down does not equate to the level of substantial assistance that was given. And, I've had judges say, you're right, and give them more than that. Go down in the guidelines, because the guidelines give you a score. It's a recommended score in months. So 24 months, 33 months, 60 months, 97 months. So and it gives you a recommendation that a judge will, that's where they start. They look at, okay, what is your recommended guideline range? And then they take into account your particular factors. What was your upbringing like? Where you, things like, if you had a tough childhood, whatever it may be, in deciding what is fair. And I have had judges very recently, in fact, earlier this year, say on the record to me, I'm not sure I hear your argument, counsel, about why what sentence is appropriate in this case. And I'm considering that because I have to live with the sentence that I give this person. And that was music to my ears. Wow, Judge, I love to hear that. You really care. You really care about, the sentence that you give my client. And that prosecutor, actually, we have another case together. That prosecutor had told me just yesterday, he said, you won that sentencing hearing. You won.
I'm always curious about that. You'll see the TV show or the movie, they're having this hotly contested trial. And then at the end, they're at the bar and they're talking about is that a thing?
Well, I had what you're talking about. I had that come up 2 days ago. we did a preliminary hearing on it. It was a human trafficking case, but it was a state human trafficking case. And it was hotly contested. I had this, of the three defendants, I was cross-examined the investigating officer like 3 times as long as the other 2 lawyers. And not that they're bad lawyers, it's just that I had more to talk about because I felt my client is innocent and you're unfairly prosecuting her.
Mm-hmm.
And when the whole thing was done, the whole case was done, my client, was walking down the hall waiting for me. And I sat there and was speaking with the investigating officer and the DA. And I was smiling. We were all kind of chuckling and laughing because I was saying to them, I was serious, but I was saying, you guys are effing my client for this. Okay.
Yeah.
She's so tangentially involved in this. Just let her go. Give me a misdemeanor, or why don't you give me a felony that I could reduce to a misdemeanor in a year and we'll call it a day. And, we were friendly the way we were saying it. I don't know if we were, it wasn't like laughing hysterically, but it was kind of chuckling. And when we walked away, my client's best friend was with her. And she said to me, she wasn't serious, but she said, "Why are you laughing with the enemy?"
Right.
And I had said to her, I'm doing what I can for my client.
Absolutely.
And I'm trying to get her out of this.
Right.
And so do you expect me to go up to a prosecutor and say, she was a woman, "You are a biatch and you need to let her go, you biatch, or else I'm going," you're not going to they're going to, that's not how you get things done. You still are negotiating with people behind the scenes, and people need to like you.
Yeah.
Okay. You need to be real. You need to be a real human being so that you're credible with these prosecutors. I've done this a long time so that people know me. They know me by name. They know my face. And I'm not going to burn my bridges with them because we're working together. Okay.
Wow.
They just can't make a decision. They have other people that are above them. They have supervisors. And so I'm giving them the ammunition to take back to their supervisor. This is what I want to resolve this case. And this prosecutor told me, by the way, I'm not going to keep this case in the trial court. Somebody else is, but because I tried to get a misdemeanor. I tried to get diversion on this case a long time ago. And I was just told, very politely, I just don't see that as happening. It's a little too low for this case. It's too serious. And there's factors why. But you can't be, this is just the way that I see it.
Correct.
Other lawyers obviously it's the way I see it because I'm saying it. Right.
But still, though, you're still making a good case, though. Your opinion still holds weight. You've been doing this for 4 decades. You know what I mean?
Right.
So I think it's still not a bad option,
Right. So, you just don't. It's not very it's not beneficial for your client to be an asshole to prosecutors. I mean, you can, in the heat of battle, when you are litigating something, it's perfectly acceptable to get upset. But getting upset, you need to control yourself because it's very important for a counsel to be self-aware,
right,
and not come off as the asshole, especially in front of a jury. I mean, that's
Absolutely.
what I think. I have colleagues that they don't care that they come off as the asshole. They're just going in there with a machine gun. They're blowing up the whole place, and that's it. I'm blowing it up.
Yeah.
And I just don't like that idea. And I try not to do that. I just try to advocate as hard as I can for my client. And I'm relentless in doing it. But I don't like to cross over to be obnoxious.
Well said. I was just curious because it kind of stuff like that fascinates me as far as how things get done. You're dealing with people. You're across from a person. The judge is a person. The jury are people. You're going to battle. But I was always curious how you approach that when you're on opposing sides. So to wrap things up, though, if someone is starting that mandatory minimum sentence, what do you want them to understand about their situation?
Well, I want them to understand that they have a mandatory minimum. They're facing a man-min. We're going to try to get you. We're going to try and see if we could get the prosecution to offer you something other than a man-min, other than a mandatory minimum. That's one thing. Number two, if you're stuck with the man-min, it depends on the type of crime it is. If it's a drug crime, see if you qualify for safety valve. I will definitely bring up in a subtle way whether or not you as the client would like to and would work for you, whether or not you want to go in and just talk to them about your crime and see if you want to cooperate. And because that is one way to get your sentence down. And it's not something that I would insist on. You have the client themselves, that's a personal decision, whether or not they feel safe, they're confident, whether their family is safe. So, there's another aspect to those man-mins. You have some situations where you have a mandatory minimum, but your guideline range could be more, okay, than that man-min. So the mandatory minimum doesn't really matter as much. You could have a 10-year man-min, but your guideline range is, 15 or 16 years. So you could tell your client, look, I don't think you're going to get the 15 or 16. We'll probably get the judge to vary, it's called to vary downward in the guidelines. But remember something, we're not going to be able to get the judge to vary downward from the man-min. But like I'm saying, some cases, it's not as an important of an issue. It's always important. I mean, who wants to go 10 years in the BOP, right? So anyway,
Anyway,
the last thing I want to say is we need to support groups that are advocating for the removal of all mandatory minimums. Let's get a fair federal system, a fairer federal system, and let's get rid of these man-mins.
Good stuff. Robert, sir, thank you so much for your time and your expertise, kind sir.
Thank you for having me. I love it.
Thank you all so much for joining us today on this episode of Criminal Law Unfiltered. Mandatory minimums can feel like a trap, but with the right legal strategy, there are often ways to fight for a better outcome. If you or a loved one is facing federal charges, visit robertmhelfend.com to schedule a consultation with Robert and his team. And don't forget to like, subscribe, leave a review, and share this information with someone that might find it helpful. Thank you so much, and we'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.